Good morning. Please be seated. We are here for oral argument in cause number UB220510, Brian Montalbano versus ADES. These proceedings are being audio and video recorded as well as live streamed, so we ask counsel please identify yourself and your client at the beginning of your presentation. Each side will have 20 minutes in which to present their argument. You are responsible for reserving any of that time for rebuttal should you choose. We have read the case. We've read your briefs, we've discussed the case, we're familiar with the facts, bear that in mind during your presentation. So at this point, counsel, if you're ready.
Good morning. May it please the court. David Keys-Nunez on behalf of the appellant, Brian Montalbano. Arizona has a robust public policy when it comes to unemployment benefits, and it's expressly stated in our statutes that it is designed to ensure that employees in Arizona do not suffer the effects of unemployment, specifically not being able to keep a roof over their family's head or put food on the table. These courts in Arizona, our courts in Arizona, have interpreted that public policy in a way that has lent itself toward a broad reading.
Counsel, we agree with that, and that's the general premise of this. What we need to kind of drill down to understand the issues in this is, did your client's conduct constitute willful misconduct? So if we can focus on the misconduct portion of the statute, point us where you want us to go, but take it away.
Yes, thank you, Your Honor. With regard to the misconduct, the answer is no. Mr. Montalbano's conduct did not rise to the level of willful misconduct. When it comes to misconduct, it requires a connection to work. And that's the first area that I think we should turn, is whether or not this conduct rises to the level that is connected with work, off-duty, and is sufficient to justify a denial of benefits.
Is it connected to work if we accept the court, if we accept the judge's view that there was a threat that something would happen at work the next day? Is that a connection to work?
It could be, Your Honor. However, I don't believe that in this case that finding by the tribunal is supported by the evidence. I don't believe the employer met their burden of proof with regard to that, so I believe the finding by the tribunal itself is erroneous.
But how much deference do we owe to that finding? If there's some intemperate language and I want a face-to-face, we need to talk, coupled with very intemperate language, do we owe some deference to that finding that this could be a viewed as a threat?
To some degree, yes. However, where the lower courts, or in this case the tribunal, considered inappropriate evidence or misapplied the law, the Court of Appeals is free to come to its own conclusions with regard to the operation of the facts and the law and the interplay, and specifically whether or not there was an abuse of discretion with regard to those lower proceedings. And that abuse of discretion could come from considering inappropriate evidence. It could come from...
Was there inappropriate evidence considered here?
In this case, yes, there was. The regulations specific to evidence, so it's Regulation 6.3.51190, specifically state the adjudicator must obtain all pertinent evidence reasonably available to make a non-monetary determination. And it goes on to say that documentary evidence is often significant. Such evidence should be fully identified and proved authentic in order to have evidential weight. Now, in this case, the lower court specifically points out a handbook that was never offered into evidence, is only briefly read into evidence by the employer, and incompletely at that. And that is directly contradictory to the regulation promulgated by the department requiring...
Didn't your client acknowledge that that was a policy of the employer? Sorry.
Mr. Montalbano, in his testimony at the hearing, said he has no recollection of a handbook. He believed common sense says, you shouldn't curse at work. However, the regulations as they relate to profanity at work. Don't say if you utter a swear word, it's misconduct connected to work, therefore you're ineligible for benefits. Specifically, they allow some variation there. So it comes down to the rules, and the tribunal's consideration of that handbook was error.
Can we go back to the threat? Was this text message a threat? Was it threatening? And I want your take on how we should read this text message, because I think the ALJ spent a lot of energy trying to kind of dismantle this text message and determined it was a threat. So if it was a threat, would that be misconduct? And if it's not a threat, why is it not so?
To take the first part, it was not a threat. It certainly had colorful language. I think it's important to consider that Mr. Montalbano had a relationship with this person he text messaged prior to that person being employed at this business. They had already known each other. Yes, the message had colorful language. However, nothing in that text message is itself threatening. He says he wishes they would have spoken face to face. He says they will talk about it. He says that he shouldn't have gone behind his back to speak to the employer. Nothing in that is threatening. And if you remove the colorful language from the text message, it's not threatening in its nature. It simply says, we're going to discuss this.
But can we remove the colorful language? I mean, the colorful language was assumingly used for emphasis and a point as to the emotion behind it and how he was feeling.
I believe we can, Your Honor. And the reason for that is, and specifically within the regulatory framework, it discusses we need to consider the type of business where this happened. These are gentlemen who work in a paint shop. They're painting trailers, and colorful language is apparently something that does get used at work because the employer testified at the hearing that he has reminded at company-wide meetings, hey, customers walk through the paint shop, we shouldn't be cursing. Hey, we have female employees here, we shouldn't be having off-color jokes. So there's indication that that colorful language is the way that these folks communicate with each other, whether it was for emphasis or not.
But even if I take your comments that it was being used, the employer was clearly making it clear that it wasn't okay.
The employer's messaging, as he testified to it, was that they were office-wide meetings about not using it because customers could walk through, or there were female employees. Neither of those circumstances were present when this text message was sent. It was sent after hours to an acquaintance of Mr. Montalbano. They weren't the circumstances the employer warned against. The second part of that is that Mr. Montalbano says he was never specifically warned. The only thing that he remembers being warned about is a single time when it was, don't make off-color jokes because we have female employees in the business. So Mr. Montalbano's testimony directly contradicts Mr. Monosmith, the employer's testimony, and within the regulations related to evidence that can be accepted.
Was there any evidence from the employer that he had been specifically warned? I know the ALJ and the state's brief suggested that there was a warning, but then in the discussion, the only thing the state references is the general policy that Mr. Montalbano was aware of. But what did the employer testify that there was a specific instance in which Mr. Montalbano had been warned about the use of intemperate language?
No, in fact, Mr. Monosmith testified at the tribunal hearing that he had never specifically warned Mr. Montalbano about his language. They were just general office policies.
So that would be, you would couch or categorize the ALJ's statement on that as erroneous, that he'd been warned previously.
Yes,
to the
Your
extent
Honor.
we're to view that as a specific warning to him.
Yes, Your Honor. That never happened, and Mr. Monosmith acknowledged that during his testimony. In this case, the department is suggesting that the definition of would, as it relates to the impact of off-duty conduct, should be disqualifying, and specifically cites a definition of would. However, would is a past tense of will, and will is something that is certain to happen. Not might, not maybe. This is going to happen in the future. That's not what happened here.
But we have to be absolutely certain that it's going to be. Is there some is there some leeway and the ALJ can consider the evidence and say this is highly likely that this is going to affect the workplace?
Yes, Your Honor, there is some leeway in it. It doesn't have to be certain. It doesn't have to have happened, but it has to be more than a merely theoretical impact. With the department's reading of that word would, it in essence gives an employer carte blanche to say, here is some theoretical harm that could occur. It would occur, as long as they couch it with the word would. Therefore, this is benefits disqualifying conduct, and our account doesn't have to be reflective of benefits being paid out. And that simply cuts completely against the public policy of the state of Arizona, because it would give employers carte blanche the ability to cut off employees they terminate as long as they can find some theoretical harm. And it brings us back to what evidence was accepted of that harm in this case and the error that.
But wasn't there
caused it.
testimony in the tribunal from the employer saying that he didn't really want to fire Montalbano because he had trouble getting painters? That would make me believe that there was a desire for or a need for painters throughout the industry, and it shouldn't really be difficult for Montalbano to find another job if he was terminated. Therefore, the whole policy and reason for the policy doesn't necessarily apply in this case because he could find another job.
So with regard to the testimony by Mr. Monosmith that he didn't want to fire Mr. Montalbano, that may be true. He certainly testified to it. There's nothing to say that that was not actually factual. However, there is a distinction between the employer's right to terminate an employee for conduct and whether or not that conduct rises to the level of being benefits disqualifying. So if Mr. Monosmith felt, hey, this text message is inappropriate for the workplace, I don't like it, this isn't how I want my workplace to run or how I want my employees to engage with each other, he certainly was free to terminate Mr. Montalbano. However, that does not mean that he is free to say, and he also doesn't get unemployment benefits. So we have to look specifically at whether or not he could be terminated for it versus whether or not it's benefits disqualifying.
So I realize that you talked about, removing the language from this text message, and you suggest that it's just a, hey, we need to talk, right? But at what point does the text message rise to the level of abusive? So I'm giving you a hypothetical here. Like, how far would it have been to go to meet the qualification that's in the standard if we accept your position?
To rise to the level of abusive, it would need to be something that is beyond a single incident of feeling inflamed, or to the point that it is on its face obviously threatening, right? I will harm you in this way. And we can turn to the regulations for support of that position. Specifically, the regulations when they speak about profanity in the workplace.
But I'm not talking about profanity here. I'm talking about abusive, because the regulation specifically talks about, it does talk about profanity, but again, you said let's remove that. But at what point does it become abusive?
I would then point the court toward the regulation where it speaks to temperamental differences between employees don't rise to the level of misconduct.
So is this really a temperamental difference? I mean, we're not talking about, oh, you and I just deal with things differently and therefore we don't really get along that well. There was an expletive used to describe a person here. At what point, I mean, you're asking us to say that that doesn't rise to the level of abusive. What more would have needed to be done to meet the definition of abusive?
It would need to be repeated conduct. If it was just this colorful language in a text message like this is, or just this type of a message, it would need to be repeated conduct. And in this case, the message was, hey, in essence was, we're going to talk. And Mr. Montalbano testified in the hearing that he was simply stating, I want to talk to you face-to-face about this, and I've asked you to talk to me face-to-face about this. So it would have to be something that evidences something beyond that, right? Something that says, I'm really just attacking you versus we have a disagreement, because employees disagree in workplaces.
How about if there were evidence that he had been aggressive in the workplace previously? Would that go to it?
It certainly could factor into that.
But I'm assuming I didn't see any evidence to that effect here.
There is none in this case. But certainly if there were past incidences, those could also be part of the calculation toward, does this now rise above? And that helps get beyond the hurdle of a mere theoretical harm of some future issue. It's now saying, hey, we've got a pattern of behavior that is not appropriate. And there's obviously the counter side of that. Do we have to wait for there to be a harm in the workplace? Certainly everybody is aware of that. But that's where the messaging needs to be something more direct, a direct threat, something that says, hey, I'm going to harm you, not we're going to talk face to face.
And you would agree with me that the ALJ determined that that was threatening?
The ALJ determined that it was abusive. Where that line for threatening is or is not.
And would you agree with me that there was contradictory or conflicting evidence presented on that issue?
There was, and
when we get to the regulations, evidence of misconduct, 6351190, we go down to C3 and it says, when there is conflicting evidence, but the adjudicator concludes that the weight of evidence supports the employer's allegations, he should hold that claimant was discharged for misconduct. So you're asking us to overturn what the ALJ said based on conflicting evidence when the agency's regulations require us to hold that. How do we get there, counsel?
through a couple of different avenues, Your Honor. The first is that hearsay was considered in this case, and the court has been very clear that the department can consider hearsay in an administrative hearing, but it doesn't have unfettered access to it. And in fact, their own regulations and the court's precedent say that where there is hearsay, it needs to be in the proper circumstances to be given probative weight, and that's in the Begay case.
But what's the hearsay evidence?
Yeah, let's
that you're-
identify the hearsay evidence you're discussing so we're sure we're along with you.
The hearsay is that Mr. Monosmith said that Mr. Pierce texted him and said, I'm concerned, this is causing me some concern, which is what Mr. Monosmith says this whole thing comes from, and what the ALJ relied on is this concerned other employees. However, Mr. Pierce never testified at the hearing, and when he spoke at the hearing, he said, I didn't have a conversation with him.
He didn't speak under oath, right? We're not. He was never sworn in.
He was
Didn't
never
provide
sworn
testimony.
in.
But could we just draw an inference from the fact that he immediately forwards a text to his boss? I mean, could the ALJ draw an inference that he was concerned? Why else would he forward it immediately? Would that be a...
That could be an inference that the ALJ could draw. However, that's really unsupported, I believe, by the fact that he said, well, not under oath, I didn't say anything to him, I just forwarded it to him. Whether or not that was because he was concerned or anything else isn't really before the court or wasn't put before the tribunal because Mr. Pierce was there. It's the employer's burden to call witnesses. The employer should have put Mr. Pierce on to express how he was impacted by that and did not. And in that case where there's hearsay, this court has said that we can overturn determinations by the department or the tribunal because that hearsay shouldn't have been admitted. And their own regulations say that the best evidence is what should be offered. And specifically, it should be evidence that reasonably prudent people would consider. Reasonably prudent people would say, I want to hear from the person rather than have someone tell me how they were feeling. It was not offered, and the employer failed their burden of proof.
Wouldn't it have been better for your client for Mr. Pierce's statement that he wasn't bothered by it to actually be considered by the ALJ, even though it was unsworn testimony? I mean, doesn't that help your client?
It does, though it appears that it was just cut off, and if you're not going to be under oath, we're not going to say anything. And the employer never put Mr. Pierce on, so we can only guess as to what I never said anything to Mr. Monosmith means. But certainly if Mr. Pierce never said anything to Mr. Monosmith, hey, I'm concerned, or this is what it is, then...
So would you argue that unsworn testimony has less reliability than hearsay that they're also allowed to consider?
The unsworn testimony is just evidence of the fact that the best testimony wasn't considered, and the ALJ in their determination said this employee was bothered by it when they sent it to Mr. Monosmith. However, that's not supported other than through Mr. Monosmith's self-serving testimony on it as an employer trying to avoid having his account reflect payment of benefits. I see I have about a minute left. If I could try to reserve that for rebuttal, if that's okay.
You may.
Thank you.
Good morning, Your Honors. My name is Jennifer Bloom, and I am here today on behalf of the Arizona Department of Economic Security. Opposing counsel suggested removing the colorful language, as we've called it, from this text message and only considering the non-colorful language, I suppose. Essentially, he suggests that we take this single text message out of its context. And the colorful language is one part of that context that I don't think we can just pretend that he didn't.
But assume we don't ignore the colorful language. It still says we need to talk. So colorful language, how does colorful language get to the level of a threat?
Certainly, Your Honor.
And before you do that, I would really like you to address the significance, whether he was ever warned specifically. Your brief suggests that he was individually warned in addition to being aware of a policy against the use of language. Was there an incident where he was specifically warned?
No, Your Honor. There's nothing in the record that supports that Mr. Montalbano was specifically warned.
Isn't that pretty significant, given statutory provisions that suggest that willful misconduct includes repeated use of foul language? So you're agreeing we don't have that here?
I am agreeing to that, yes. However, I would also note that the regulation says that the employee has to have been warned about the use of profane language, but nothing in that says he specifically has to have been told, hey, you can't use.
There's a difference between stating a policy. Here's the company policy. We're not going to use foul language because there are customers and women present. No off-color jokes, etc. Is that a warning, or is that just a designation of what the company policy is?
And here you in your, sorry, go ahead and answer that first.
Your Honor, I do believe I think that is a warning. The use of the term warn is say, okay, you've been told that this conduct is not allowed in the workplace.
And here, in your brief, you started off by saying it was the company policy and he had been warned. Did I misread that? Which to me suggested that there was a policy and he'd violated it in the past and had been warned. So why would you separate that out and say not only was there a policy, he had been warned. There was a policy that he was aware of and he had been warned. So why would you put that in if it just means the same thing as you're on notice through our company policy?
That was referring to Mr. Mona Smith's specific verbal warnings to all employees. That was what the distinction that I intended. You have this written employee handbook, and the employer has also repeatedly told all the employees, hey, this conduct's not allowed in the workplace. As I think when we get to the purpose of that policy, that the employee has to have been warned, well, the idea is the employee has to know, okay, you're not allowed to use profanity in the workplace.
He knows that by seeing a handbook. He acknowledges that that's a policy. He says it's common sense. But it seems very different if there hasn't been, if it's not repeated, and that's what the statute says, willful misconduct includes repeated use of foul language.
I think it also gets to the point of, you talk about in the workplace, but, to your counsel's point earlier is, this was outside of the workplace. This wasn't in the shop where work was actually going on, which is our understanding as to what the warning was targeting. This was a text message sent off work hours. So why would that warning apply to this text message?
I think that goes to the employer has expressed the type of language that he wants coworkers to be using to communicate with each other. And this text message is a very blatant violation of that policy.
If we actually go with Mr. Montalbano had been warned, the warning that was given is we don't use foul language in the shop because there are women and customers present. That's the warning in the shop, and the reason our people are present. Neither of those conditions are met in a text message between two male employees. So if we're going to go with the company's policy and the warning he received, that warning, you would agree, would not be applicable to an off-hours text message, would it?
Since, without the specific language of what was said, nothing expressly says you can't use profanity when you're communicating with a coworker during off hours.
So did he actually violate the company's policy?
He definitely violated the company's policy of not using harassing and abusive language, even if we don't count the use of profanity.
Okay, so do you believe this text message is threatening to the recipient?
Yes, Your Honor.
Explain why.
So, as I was saying earlier, we have to consider the context of the message, not just the message itself, but we know that before receiving this text message, Mr. Montalbano had been told by the employer, hey, we're going to have a talk about changing your work employment to your detriment. We're talking about putting you on hourly instead of salaried because you've been missing a lot of work time. So we know that that's just happened. Then we have this text message that the employee says, hey, I hear you're saying bad things about me to the boss, and I want to talk to you about that. So in that context, if the text message had, as Mr. Montalbano suggested, just said, hey, I want to talk to you about this, let's discuss this face to face.
How about if he just said, I'm very unhappy with you. I'm very angry. I want to talk to you at work. Does that create a threat?
I don't think that specific language would create a threat.
So I'm just having a hard time understanding the threat. The threat that something's going to happen at work that's going to affect the business. And wouldn't the same thing happen if someone said, your son wants to date my daughter, and I will never let that happen. We're going to talk tomorrow at work. Wouldn't you agree that there would be an uncomfortable discussion at work the next day that would not be great for the work environment? Would that be something that would disqualify you from receiving benefits? And how is that threat different than just having used some intemperate language and saying, we need to talk?
Well, I think the use of the intemperate language displays the emotion of the person sending the text.
I can say, I'm furious with you. I'm very angry. It seems to me you've kind of relied on, there's a company policy that we seem to be viewing differently, that's a policy of not swearing and using foul language in front of customers. And if they're doing that, I'm just having a hard time understanding why that's different than me saying, I'm furious with you. You've really upset me. We need to talk.
Well, Your Honor, I think the person's viewpoint who is most important here of whether or not this is a threat is two people who are not us, Mr. Monosmith and the employee who received the text. And Mr. Monosmith testified that he, who actually was familiar with Mr. Montalbano and his personality, thought it was a threat.
A threat to do what?
There is not anything specifically outlined, but I don't think...
But don't you need something a little more? I mean, a threat seems pretty harsh. I mean, if you agree that there's no prior evidence, there's no evidence of prior aggressive behavior by Mr. Montalbano?
I agree. Nothing in the record shows that there was aggressive behavior known to Mr. Monosmith before he made the decision to terminate Mr. Montalbano.
So when we look at this, kind of the gestalt of the issue, Mr. Monosmith met with him, said, you've been absent too long. So Mr. Monosmith was not happy with Mr. Montalbano. Mr. Montalbano then sends this text. So the next thing Mr. Monosmith receives is this, whatever it is, text message sent to another employee. He said he didn't consider the absenteeism, et cetera, et cetera. The only issue was this text message. So when we look at what was the result of this, we have an unsworn statement that says, no, I wasn't scared. I just sent it to Mr. Monosmith. Mr. Monosmith receives it and immediately terminates him, does absolutely no investigation. The questions we've been asking you are, is this a threat? Is it because of the harsh language? These kinds of things. None of those questions were asked during the hearing. So we're left with Mr. Monosmith saying he considered it a threat, unsworn testimony or no testimony at all that it was not a threat. We can't say that it was specifically some action was going to take place when they had their talk. So if it's just the abusive language, the statute requires it to be repeated use of abusive language or profanity. Would you agree with that?
Excuse me.
Let me get it. 28.619.01 subsection 23.619, what'd I say?
28.
Oh, you know, an 8 and a 3. So it says specifically, insubordination, comma, disobedience, comma, repeated and inappropriate. So we have to have more than one instance if it's just the use of inappropriate, abusive language. Do you agree with that?
I would then look to the regulation that's more specific about profanity, which does actually say that we can if we have subsection B2, when it's used in a belligerent or vociferous manner and there's interference with good order and discipline, that rises to the level of misconduct.
And I think when we look at that subsection, that's between employee and supervisor, not between co-equal employees typically. Now, I might be wrong because I read a lot of the regulations, but.
Your Honor, I'm scanning it over and I do not see anything in that regulation that references that.
Give me the site.
Certainly, that is AAC R6-3-51390.
Okay.
But do you think that trumps 23.619 that suggests that it has to be repeated use of foul language?
Obviously, the regulation does not trump the statute, but the regulation gives more insight into how we look at misconduct and instances of misconduct.
But repeated seems like a pretty easy, but I don't need much insight to understand what repeated means. And that's where you've given somebody a specific warning if they've done it in the past, and that wasn't the case here. So I'm having a hard time getting past 23.619.
Well, Your Honor, I suppose we could consider this. This isn't if this text message isn't one use of profane language. It's I would guess about 10. I don't have it verbatim. So if within this text message we do have repeated use of profanity.
We would not say that in a criminal context. We would not prosecute someone for repeated. Neither here nor there. But assuming we don't buy that, do you have any other argument on that? Assuming I don't buy that, I can't speak for my colleagues.
Certainly, Your Honor. No, I do not have another argument on that.
Could I ask you just, if you guys don't have something, I'm a little bit curious. I know another panel of this court has asked about the state's role in appearing in these proceedings. And I know they received notice of them, but it seems a little bit inconsistent with what happens in special actions under the Hurls case. And I wondered if you've had discussions or had any, since that argument in front of a different panel, just the general notion that in special actions, the state only appears if there's something that goes to a policy of the court that issued the ruling. Is there a difference between Hurls and this case? Where we typically would not have, we would expect the employer to come in and make an argument. And I realize it's been done and we haven't asked you to brief it, but I'm just curious if you've had any more, if you've had any discussions on that or have any thoughts on the state's role in coming to essentially defend the employer's decision.
Respectfully, Your Honor, I'm not prepared to discuss that issue. I have heard about the case, but I have not read it recently, and I'm absolutely not prepared to discuss its implications.
The case has not come out. It just came up during argument, and all right, fair enough.
I would say, however, that DES does not always come in to defend the employer. We come in to defend the administrative decision, and in fact, I will be seeing you again next January to argue in favor of a decision that went in favor of the employee. So to say that the state comes in to defend the employer is inaccurate.
Except that it's in the Hurls case, it said the state doesn't come in and defend the decision maker, the ALJ. It said the only time you do that is if you're defending a policy of the court, and not just coming in to say, yeah, the court got this one right in this case. And so that's, regardless whether the judge ruled in favor of which side, Hurls says we don't do that. And this may be different. I understand this is a different context than Hurls, but it still seems a little bit unusual, and but maybe at some other point where we'd like to have briefing, and we'll give you that opportunity.
I would be happy to submit supplemental briefing on the issue if the court feels it's appropriate.
Okay, let's get back to this.
Okay.
So, you have this determination by the court. If we accept that this is a threat, then we have to extrapolate into the harm to the business. And because he was fired immediately, there was no opportunity to develop that harm. So I'd like you to speak to that point.
Certainly, Your Honor. There's nothing in our regulations that suggests that an employer has to wait and see what happens to see if harm is actually going to come when they have a reason to believe that there's a threat to the safety of employees in the workplace. And so the case specifically that supports that I cited in my brief was one in which the employee had failed a test for cocaine. He had not actually caused any harm yet, but the employer knew that that would cause harm to the business. So nothing here says that, oh, the employer they have to do more investigation, they have to wait, they have to see if a threat actually manifests.
There's usually, I think there are accepted consequences to cocaine use. We have to draw this inference that there's accepted consequences to saying we need to talk. So it seems a little different than someone we know is using cocaine and is going to show up at work, than just someone who says, when I get to work, we need to talk.
So I think, Your Honor, that there are accepted consequences to threatening your coworker as well, and which is what the ALJ believed. And Mr. Montalbano's counsel actually conceded that it was a reasonable inference from the evidence that this was a threat. And this court will affirm when it finds that the evidence or the reasonable inferences therefrom support those findings.
So if we don't find it was a reasonable inference of a threat, is he entitled to benefits?
I think he would at least be on much better footing. I don't necessarily want to say.
What would be the reason for denying benefits if we disagree that there was an actual threat?
Well, Your Honor, we do still have the use of profanity, which is, but I don't think I think that it is very clear from these circumstances that this was considered a threat. This is what the employer testified to, and he said, Mr. Pierce also told me he felt uncomfortable from this. And Mr. Montalbano's argument that that statement was hearsay first comes too late. It was not raised until the reply brief, so this court may, in its discretion, consider that argument waived. Second, hearsay, which is not objected to, is considered competent evidence under the law of this state. And yes, that's what I had to say about hearsay. Sorry. With my remaining time, I would just like to once again bring up the issue of 41-1993B. That is a statutory prohibition on the issues that this court can reach on appeal. This court has said it's not a discretionary choice. It is a statutory limitation.
You're saying he didn't raise the issue that I didn't do anything that created a threat to the workplace? This was an after-hours text, and all I said was, when we get to work, we need to talk. You're saying that didn't preserve his appellate issues?
No, Your Honor. What he actually says in his petition, the main thrust of it is everything is lies. He says...
I read his testimony there at the hearing. You would agree that at the hearing he certainly said, I sent a text after work. I didn't say anything other than I used foul language, but I said, when we get to work, we need to talk. We can't consider that?
Your Honor, the statute does not say the issues raised at the tribunal and in the petition. It says the issues raised in the petition for board review. So when we consider the application of 41-1993B, the court is limited to what's actually stated in the petition for board review, which simply says this is all lies. And respectfully, the only point of contention here is whether this was a threat. Mr. Montalbano has never disputed that he did, in fact, send this text message.
But he says this is a lie to say that it's a threat. I'm
He does not say that, Your Honor,
Well,
sorry.
he says this is all lies. I'm not following how we would not have the authority to consider these issues.
So raised in the petition, and we have pro pers that are actually the ones filing the petitions for review. How specifically would he have had to raise it?
If his petition for board review had said, I don't see how this is related to my job, I would consider that not waived. Basically, I think we do read it with some lenity because it is typically a pro se application. But I would say that the standard needs to be that the appeals board can reasonably foresee these are the arguments that are being raised and have a chance to respond to them. And nothing about this petition for review says, I don't think my misconduct was connected to my employment. I see that my time has run, so unless this court has further questions.
Can I ask another question?
We've got one more for you.
All right.
So we'll probably need to address time. But you talk about his petition doesn't talk about, doesn't say that he this wasn't in the workplace, but it says never ever use profanity in the workplace. So isn't he saying this didn't happen in the workplace and bringing up the very issue that you're saying he doesn't bring up?
In the context of it, he's saying the allegations are lies. So,
but that specific sentence says, I never use profanity in the workplace.
Correct, and nobody has ever disputed that. I don't think that the board could have read this petition and thought, oh, okay, what he's saying here is that this isn't misconduct because it didn't happen at work.
But isn't the whole crux of the department's decision that this text message was in the workplace?
Yes, but that is one small portion of the overall argument that he makes here.
Thank you.
Thank you, counsel. And
Thank
if
you,
we
Your Honor.
could add, let's say, 1 minute.
Just to comment briefly on the final part of the department's argument there, Mr. Montalbano's petition should be read liberally. That's consistent with the state's policy to broadly apply benefits. We're talking about unemployment benefits, so these are folks who are not likely to be able to go out and pay for an attorney to do this more artfully. And in one of the first cases addressing pro se litigants, the Ackerman case from the 1930s, it specifically references individuals with resources are held to a higher standard. In this case, the petition should be read liberally as to the issues raised on appeal. With regard to this court's review of this case, this court may substitute its judgment for the agency's conclusions regarding the legal effect of the facts. That's already been stated in the Weller case and repeated numerous times since that case was decided. It is the employer's burden of proof. In this case, the proof considered by the ALJ was not appropriate for the reasons we've already discussed. Mr. Montalbano is respectfully requesting that this court reverse the board's decision and remand this case with instructions to award benefits, if there are no other questions.
Thank you, counsel.
Thank you.
Thank you both for your arguments here this morning. We will take this matter under advisement and issue a written ruling in due course. We are at recess.